Ulster Bank have won an appeal in a tracker mortgage row, a very important case with the Ombudsman. The Court of Appeal has found that two borrowers gave up their contractual right to a tracker rate when they moved to a fixed rate. The Court of Appeal has struck down decisions that bound Ulster Bank to pay two borrowers tracker mortgage refunds and compensation. The key issue in the cases was whether or not the borrowers, having switched their interest rate, had a legal entitlement to return to a tracker rate from which they had earlier moved when ECB rates were rising. Ulster Bank refused their requests to revert to the tracker rate. The Court of Appeal, it has found that the complainants gave up their contractual right to a tracker rate when, having agreed to a variation in their mortgage contract, they moved to a fixed rate. Tracker rates rise and fall, the interest rates with the interest rate set by the ECB. They were introduced in Ireland in 2001, but the bank stopped offering the product after it became loss-making during the financial crisis. Ulster Bank stopped offering the rate to new customers in 2008. These two borrowers took their cases to the Ombudsman for Financial Services. They were excluded from the redress scheme. There was an industry-wide mortgage tracker scandal examination overseen by the Central Bank between 2015 and 2019. The Ombudsman's binding decisions in these two complaints had been upheld by the High Court and could have led to the lender Ulster Bank paying compensation to thousands of similar customers in Ireland. The Court of Appeal, however, has now ordered that the Ombudsman needs to hear the complaints again after finding his interpretation of the mortgage contracts was incorrect. In one of the complaints, the Ombudsman held that the lender had failed to explain to the borrowers that they'd lose their entitlement to a tracker rate when they switched to a fixed rate. Similarly, he ruled that the bank owed the other complainants a duty to clearly explain that by signing a fixed rate transfer form, they were giving up their right to a tracker rate. The Ombudsman directed repayment of any overpaid interest and compensation of $3,500 in each case. This could have opened a huge can of worms for Ulster Bank. The Court of Appeal said that the first set of complainants took out a tracker rate mortgage that was fixed for the life of home loan term, but on transferring to a staff fixed interest rate, this new rate was fixed for the term of the loan. It's clear by moving a portion of the loan to a staff rate, these complainants were agreeing to a variation in their contract concerning the applicable interest rate, the judge said. They identified no contractual entitlement to return to a rate of interest which they had agreed to move from. The contractual analysis was similar for the second set of borrowers. The fixed rate transfer form they signed in May 2007 stated clearly that at the end of the fixed period the bank may offer alternative available products. It did not say the complainants would have the option of returning to a tracker rate. The judge said that the Ombudsman, the Financial Services and Pensions Ombudsman, was incorrect to find the bank's conduct was contrary to the law in relation to these customers. The court also held that the Ombudsman, his conclusion that the bank's behaviour was otherwise improper was based on his finding that the complainants were unaware, did not understand or did not have explained to them that by moving to another rate they would lose the tracker rate. The judge said that it was difficult to see how this conclusion was reached when the Ombudsman's decision was based only on documentation, as he had refused to hold oral hearings. Attempting to establish the level of understanding the borrowers had is a subjective exercise, the Court of Appeal said, adding that the documentation does not give the answer. That's the decision of the Court of Appeal. Ulster Bank will be heaving a massive sigh of relief. This will obviously be a case that will be watched closely when it goes back again to the Ombudsman, but essentially the High Court decision and which upheld the Ombudsman's original decision has been overturned now by the Court of Appeal, and this was to do with somebody being on a tracker rate and going over then to a fixed rate and then wanting to move back to the tracker rate. Essentially the Court of Appeal has held that the tracker rate was no longer available to the borrowers when they had departed from it, as it were.